Good evening and welcome everyone. Welcome to tonight's lecture. Um, our speaker today will deliver the lecture in English. If you need the live interpretation, we offer Korean, Cantonese, and Mandarin channel today. Please click the interpretation button in the lower side of your screen and choose the associate channel. For those who need Cantonese interpretation, please choose French channel instead. Subtitle and sign language is also available today. For those who want to watch the sign language, please pin the sign language interpreter to your screen so that you can see watch the interpreter always. For subtitle, please click the subtitle button in the toolbar of your in the bottom side of your screen. We are about to start our lecture today. Hey, Mike, please keep your microphone in the silence mode so everyone can hear the speaker clearly. Our schedule will be quite packed today. Please feel free to leave your questions and comments in the chat box. Our questions will be gathered and answered later in the Q&A section. Our seminar today is about to begin. Once again, I want to welcome you all in joining this seminar. This seminar is originally designed for the Chinese-speaking community in Asia. So most of the inclusion support are provided for Chinese-speaking community in Asia. We are happy to see more other from different parts of the world want to join us today. We are really sorry for we are not able to accommodate everybody's need, all kinds of inclusion support in a short time. Wish we could send them a follow-up information so that you will not be disappointed. So right before the lecture, I want to introduce our organizer. Our organizer of this lecture is Inclusive Asia. Inclusive Asia officially become a registered non-profit limited company in Hong Kong on 2018. Our aim is to have the Chinese-speaking communities in Asia to explore and implement the United Nations CRPD by promoting exchange, integration, and support throughout the Asia region. So it's about time. We will start our seminar very soon. Today we have Wang Yi as our moderator. Now I want to pass the time to Wang Yi.
Thank you for Enso's introduction and explaining the technical issue. So welcome everyone to today's lecture. As a quick information for who are coming for the first time, tonight's lecture is one of a series of lectures on the right to access to justice for persons with disabilities. We have invited guest speakers with diverse backgrounds to share with us their expertise and experience from different perspectives. We hope this can support people in the Chinese-speaking region to develop insights of the right to access to justice and see how people from other countries and regions are working on this issue. We would like to thank the Institute for Research and Development on Inclusion and Society and the Ability Beyond Borders for their support. Today is the third lecture in this series. We are honored to have Professor Wim Martin from University of Essex. Professor Martin directs the Essex Autonomy Project, which is a research and public policy initiative investigating the idea of self-determination in context evolving care and disability. Now I hand over to Professor Martin.
Wonderful. Thank you, Wang Yi. It's a great honor for me to be invited to work with colleagues from Asia. And I want to thank Inclusive Asia for the invitation today, and also IRIS for many years of fruitful collaboration. I've prepared some slides today and some remarks. So I'm going to work through those. I gather there's a chat function to put questions in, but I think I won't pay attention to that. We'll take a break at about 9 o'clock, and then we can have a discussion following that. I think it's a very exciting moment in the history of law reform all around the world. And it's a really wonderful opportunity to bring together people from different parts of the world to think about these challenges together. Finally, I just want to bring my greetings from the University of Essex, and in particular from my colleagues in the Human Rights Center here, and from our group here, the Essex Autonomy Project. I should say here at the outset that I am a philosopher by training. I'm not a lawyer, but I've been working for the past 15 years or so on these issues around the ideal of autonomy in contexts of disability and care. And as you will know, it's been a very exciting time to be working in that area. So today I'll bring you some perspectives from our research group. And I want to report on some research that we're working on right now in collaboration with IRIS. But I'll also lay out some of the fundamentals in this area. We're a large and diverse group, and so I don't want to take too much for granted. So I apologize in advance if I start by telling you things that you already know. So I hope you can see here on the slide, the title slide, my title for today, Respect for the Will of the Person, Legal, Historical, and Philosophical Perspectives. Let me just start by framing a question here. This is a question that I think is the question for our time. Here's my formulation of it. How shall we devise new regimes of legal capacity which are respectful of the rights of older persons and persons with disabilities, and which are maximally inclusive of populations that were previously excluded from full recognition in society? That was a formulation of a question that emerged from last year's World Congress on Adult Capacity in Edinburgh. That was a Congress that brought together activists, researchers, policymakers from all over the world. And it felt like there was a real consensus that that was the challenge of the day. We have had, for thousands of years, exclusive regimes of legal capacity, regimes of legal capacity that leave people on the outside. And the challenge is to devise more inclusive regimes of legal capacity. After that point, people go in different directions. Different jurisdictions have gone in different directions. Some people want to go further than others. In some jurisdictions, there's an appetite for fundamental law reform. In other jurisdictions, people are working within the existing legal system. And so we've been tracking those different developments now, and to see what's emerging in this very fertile period of reform of law and practice. That's my question. I think that's our question. For today, I want to focus on what I think is at least part of the answer. And here's my short formulation of it. I want to argue that we need a better understanding of what I'm going to call the practices of will recognition. We need to be able to recognize the will of people in order to afford them full legal recognition. In order to respect the will of people, we need to recognize their will. So that's what I want to focus on today. It's a research project, but it's also a public policy challenge. And you'll see here on this title slide, those two red terms, regimes of legal capacity and practices of will recognition. I hope that the meaning of those terms will become clear as we proceed. So I have several sections here. I think maybe there's 7. None of them are very long, I hope. Part 1 here is about the law. So I want to really start here with some what I'm calling raw data from the law. So let's start from this. I expect most, if not all, participants in this seminar will be familiar with this bit of text. These are the first 3 sections of Article 12 of the United Nations Convention on the Rights of Persons with Disabilities. As you'll know, the UN CRPD was adopted by the UN General Assembly in 2006. It's the most recent of the UN Human Rights Conventions. It's very widely ratified. And we're now at a point where it's beginning to be bedded in to legal practice, to law reform, but also really into frontline practices of interaction with persons with disabilities. So it's an exciting time to be working in this area. We'll see here Article 12, often described as the heart of the convention, is about equal recognition before the law. There's nothing new about equal recognition before the law. It's a fundamental of justice. It's a fundamental principle of human rights. We all deserve equal recognition before the law. And we can see here actually in section 1, it says states parties reaffirm that persons with disabilities have the right to recognition everywhere as persons before the law. So this is not new, this is a reaffirmation. But subsection 3 of Article 12 does begin to take us into new territories, which is about the obligations of states parties to take appropriate measures to provide access by persons with disabilities to the support they may require in exercising their legal capacities. So a crucial question here for all of us in this period of innovation in this area of law and practice, what should those support measures look like? That's the question we have to be grappling with. I won't read you the rest of Article 12, but I do want to focus in on one word here that's particularly important for my argument here today, and that's the concept of will. In Latin, voluntas, the root of our term voluntary in English, la volonté in French. The concept of will appears here explicitly in subsection 4 of Article 12 in the context of safeguarding measures. And we'll all, I think, be familiar with this idea that safeguards need to ensure that measures relating to the exercise of legal capacity respect the rights, will, and preferences of the person. So in order to come to terms with Article 12, we need to think about what that respect for the will amounts to. What should those safeguards look like? What is it that we're trying to safeguard? But I want to argue that there's a second appearance of the concept of will in Article 12, but it's just beneath the surface. And it lies underneath this notion of legal capacity. Article 12 is all about providing support to guarantee the recognition of legal capacity for persons with disabilities. But what is legal capacity? Well, legal capacity is defined by the Committee on the Rights of Persons with Disabilities, the treaty body for the convention, in General Comment 1. So I've just picked one little extract from General Comment 1. I won't read it all. Legal capacity, they say, includes the capacity to be both a holder of rights and an actor under the law. So people sometimes distinguish between passive and active legal capacity. To have passive legal capacity is to be a bearer of rights. I have a right to life. That's my passive legal capacity. But active legal capacity is the ability to be recognized as an agent under the law. I can make changes with legal effect. And the second passage here that I've highlighted spells that out. Legal capacity to act under the law recognizes that person as an agent with the power to engage in transactions and to create, modify, or end legal relationships. So as we know, all over the world, persons with disabilities are treated as bearers of rights, as having passive legal capacity, but they are very often denied legal agency. They're not treated as persons able to engage in transactions and to create, modify, or end legal relationships. Under many jurisdictions, a guardian is appointed. The guardian has the ability to make those changes with legal effect on behalf of the person with disability, but the person with disability can't do so. In the worst circumstance, if the person wants to change their guardian, they need to go to court in order to do that, but they can't do that themselves because they lack legal agency, a kind of catch-22 situation. So that's this concept of legal capacity unpacked into this idea of legal agency. But what I now want to show you is the way in which this notion of legal agency, the ability to make changes with legal effect, itself implicates the will, the concept, the legal doctrine, the legal concept of having a will in a matter. So one way to see that is to look at civil codes. I'll show you 3 examples, but we could go through many, many more here. Many civil codes begin with a general chapter in which they offer definitions of central terms. Here's some examples. The first one here is from the Netherlands, here in Europe. And one of the definitions, very early on, you can see this is section 3.3. So very near the top or deep in the foundations of the Dutch Civil Code, we find this idea, a definition of a juridical act. What is a juridical act? Well, juridical act is a thing like signing a contract, getting married, appointing a solicitor, bringing a lawsuit, all of those things about making changes with legal effect. A juridical act is the genus to which all of those specific actions belong. And how is it defined? A juridical act in the Netherlands requires the will of the acting person to establish a specific legal effect, which will must be expressed through a statement of the acting person. So in the Netherlands, in order to be able to engage in a juridical act, in order to have legal agency, I need to have a will and I need to be able to express it. The second one here is from Peru. This is the Peruvian Civil Code in Latin America. Again, in their opening chapter of their civil code, we get a definition of a juridical act as a manifestation of will intended to create, regulate, modify, or extinguish legal relationships. So again, the notion of juridical act, very fundamental notion, is defined in terms of will. It's interesting, in neither of those cases is the notion of the will itself defined. The term will is left undefined as a kind of legal basic in these civil codes. And then the third one is from the German Civil Code, which defines the negative term, the incapacity to transact. A person is incapable of transacting if he's not yet 7 years old, or he's in a state of pathological mental disturbance that precludes the free exercise of will, unless the state by its nature is a temporary one. So we can see in all 3 of these civil codes, and there are many, many more like them, that this fundamental notion of legal agency, of being able to be recognized as a legal agent, is tied to this notion of having a will in a particular matter. That might be that I'm consenting to a medical treatment. I express my will that I want the doctor to carry out that on me. It might be to sign a contract. My will is to purchase this piece of property or to sell this piece of property. Across the board in civil law, the notion of the will is bedrock. One thing I would love to know more about is the way that plays out in the civil codes of Asia. And perhaps that's something we might discuss in the in our question period. For now, let me move on. I've been unloading quite a lot of legal detail here in the first part of my remarks, but what's the upshot? What's the significance of all of that? Well, I put it in terms of these 3 lines. First of all, equal recognition requires legal capacity. Secondly, legal capacity requires legal agency. And thirdly, legal agency requires will recognition. So in order for me to be equally recognized before the law, people need to recognize that I have a will in a matter. I hope that's clear so far. And what we really need to be thinking about now is the way in which that impacts upon persons with certain kinds of disabilities. And in particular, I'm thinking of persons who are living with communicative difficulties or with severe intellectual disabilities, such that they are not typically recognized as having a will in the matter. These might be people who are described as having no language, for example. So these might be very severe intellectual or communication difficulties, which has in the past precluded them from being recognized as having a will. I've been talking so far about these fundamentals of law, but we need now to think about these, what I've been calling regimes of legal capacity. How is society organized? How is the law organized so as to define who has legal capacity, who is recognized as having legal agency? What I've been arguing so far is that depends a lot on who is recognized as having a will. This beautiful mosaic here is a mosaic of Emperor Justinian, who lived in the 6th century AD. He was an emperor of Byzantium, and he did a lot to organize the law of his time. He was responsible for the Justinian Code, and I've just given you one short Latin extract here from the Justinian Code. Furiosi voluntas nulla est. That means the will, voluntas, of a madman is nothing, is nulla, is void. You can see the same thing here centuries later in Black's Law Dictionary from 1910. The madman has no will. So this is a principle of exclusion baked deep into the history of civil law, according to which certain groups of people simply do not have a will. There's no will to respect, so they're incapable of exercising legal agency. Now that is we call that the Justinian axiom, and it casts a very long shadow over the whole subsequent history of law all over the world. And again, another thing I'd be interested in is to find the ways in which that principle plays out in Asian contexts. But think about that principle of exclusion. What's the upshot of the Justinian exclusionary axiom? Well, let's go back to our list. Remember, legal agency requires will recognition. So if you don't recognize my will, then you don't recognize my legal agency. Legal capacity requires legal agency. So if you don't recognize my legal agency, you don't recognize my legal capacity. And equal recognition before the law requires legal capacity. So if you don't recognize my legal capacity, I don't have equal recognition before the law. So I hope I've convinced you that this idea of being recognized as having a will in a particular matter is of enormous importance. And having people recognizing my will means they can recognize my consent or my refusal or my being a party to a commercial transaction or as somebody who can bring a lawsuit. And so where will recognition breaks down, the whole thing collapses and people are left outside of a whole regime of legal capacity. They are still bearers of rights. Simply in virtue of being human beings, they are bearers of rights, but they've lost that ability to exercise legal agency. Okay? Those were the old paradigm legal arrangements, but let's just take a quick look at some of the new paradigms in legal arrangements. So I'm giving you two examples here. Both of them are from Latin America. These are from some of the most progressive law reforms anywhere in the world right now, and they're both from the last 5 years or so. The first of these is from Peru, from 2018, the legislative reform that abolished guardianship in Peru. The interesting and also guaranteed support measures for persons with disabilities. But it's interesting when one starts to look at the detail of the Peruvian law reform, we find that the concept of will is coming up again as a boundary marker. So this particular section of the Peruvian law reform focuses on the circumstances under which a judge can impose support measures on a person. The default is a person should be able to refuse support. I should be able to say, no, thank you. I don't want your support. That's very kind of you to offer. Go away. And in general, the Peruvian law reform allows that. Support should be offered, but it should not be imposed. But as we see here, there are exceptions. Always look in a statute for the word exceptionally. What are the exceptions? And so here we find the exception. Exceptionally, a judge can determine the necessary support for persons with disabilities who cannot express their will. This measure is justified after having made real, considerable, and pertinent efforts to obtain an expression of will from the person. So can you see here that the concept of will under these most progressive law reforms is marking a crucial boundary? If I'm not able to express my will after you have made efforts to determine what my will is, then the courts can impose support measures upon me. So determining that when that condition is met is now a new legal threshold and a site of litigation in the Peruvian context. We find something similar in the Colombian law reform from the following year, 2019. Again, it's an exception. In this case, it's a case where the supporter can request authorization from the judge to act on behalf of the person. Again, the default is that a Colombian person with disabilities, it's up to them to appoint their own supporters, but the Colombian law reform allows that there may be circumstances where the supporter can initiate the process and the judge, the courts, can sanction it. So what does it say? The supporter may request authorization from the judge to act on behalf of the person, provided that the following requirements are met. And here it is, that the holder of the act is absolutely unable to express his will and preferences by any possible means. Okay, so can we see here, under the old legal paradigm, recognition of the will was used as an exclusionary mechanism. People were excluded from participation in a regime of legal capacity. In these new paradigm legal arrangements, the concept of the will is marking new boundaries in the law and also areas where the courts can act to appoint supporters or impose support arrangements. So a key question for us in operationalizing these new legal arrangements is to understand better what that threshold is. What does it mean to be able to express a will or unable to express a will? What counts as a real, considerable, and pertinent effort to obtain an expression of will? These are new questions that have emerged in the law in the last few years as we try to introduce new paradigms in the fulfillment of the requirements of Article 12. Okay, enough law. It's not going to go away, but let's turn our attention now to some philosophy. I'm on to part 2, and you'll be happy to hear I only have one slide for part 2. So part 2 is called will recognition, the practices of recognizing someone as having a will in a matter. I've used this image here of a marriage ceremony. This is a medieval European marriage ceremony. And we can see here the bride and the groom and the members of the family. But what I want to focus on in this image is the image of the priest, the representative of the church and of God and of the community who is presiding over this marriage ceremony. Part of the priest's job, not just in this moment, but in the period leading up to it, is to recognize the will of the two people to marry each other. Typically, a priest will meet with the couple, the bride and the groom, either together or separately or both, to talk to them. And his job is, well, I'm calling it will discernment. In the first instance, he needs to see that both of these people want to marry each other, that they have the will to engage, to exercise their legal agency in committing themselves to a binding legal arrangement. Partly that means, being sure that neither of them is being coerced into this marriage. So that's what I call will discernment. I really think of it as being almost like perception. I can see what the person's will is in this matter. Sometimes it's very easy. Sometimes it might be more difficult, but it's an interpretative perceptual activity to figure out what someone's will is. And in this particular case, the will to marry. Will ascription is then the next step in this. Will ascription is a speech act. It's when the priest says, yes, these two people do have the will to marry one another. He might say that out in court, or he might sign a document which says that. He's the witness on the marriage certificate. And at that point, he's saying these two people have the will to do this binding legal thing. Sometimes notaries do that same sort of activity. They certify that someone has a will in a particular legal matter. And then the third stage in this, and I have to emphasize this, we often don't get to the third stage, is what I'm calling will attestation. And that's where I might arrive in court or before a tribunal, and I now need to provide evidence about the will that I've ascribed to the person. How do we know that this is the person's will? How did you know? What was the evidence you relied on in specifying that this was a person's will? Now, oftentimes we don't get to that. Attesting to a person's will is a highly specialized thing, and it only comes in rare circumstances. But when it does come up, it's important. And I think we need to be clear about how we do provide evidence to support a will attestation. And in particular, if we might be talking about someone who has a severe cognitive disability, or who might have very advanced dementia, or who might be lacking in anything we would normally recognize as language, if we don't recognize them as having a will, they're excluded from full recognition before the law. So how, if it comes to court, do we provide evidence that this is their will in this matter? So that's the whole a cluster of this kind of three stages of will recognition. All of those three things together, I'm grouping under this heading of recognizing a person as having a will. And the legally significant part of this really kicks in at the third stage. So with that kind of framework for thinking about this, we arrive at a really, what I call a basic science research question. How do people do that? We do this all the time. And people who work with persons with severe disabilities do it all the time in their interactions with them. How do they discern what their will is? How do they ascribe a will to the person? And how, when they need to, can they evidence that fact? So a basic kind of task for research here is to try to figure out how the kind of hermeneutic experts go about that kind of business. But that in turn leads to a basic policy question, in particular about will attestation. What should the standards be for validity in will attestation? What counts as a compelling case that this person wills to do this or that? How, if the person has a severe disability, they can't communicate in using natural language, how would you go about reassuring yourself and providing evidence that, for example, they want to get married or that they want to sell or acquire a piece of property? How do we go about doing that? What are the norms, the standards for valid will attestation? So to me, that is a key stepping stone to realizing the potential of law reforms inspired by Article 12. Part 3, empirical hermeneutics. I don't have any slides for this one. I just want to tell you a little bit about some work that IRIS is doing. So this is the Canadian NGO, a sponsor of this seminar series. It's led, this work is led by Michael Bach, but in collaboration with a lot of other people, and I've been advising on it. So this is an attempt, a study, an IRIS study that is an attempt to answer that basic research question. How do supporters go about ascribing a will, recognizing a will, attesting to a will? It's a video-based study where members of the research team spend time with what we call hermeneutic communities or decision communities. These are groups of people, often involving a person with a severe disability, plus family members and other supporters. The research team goes in, spends time with them, videos their interactions. The team then goes away. They edit that recording, and then they come back and show the edited recording to the family and the supporters, and they do a stop-start methodology where they ask them to explain what it is that they're doing. How are they making sense? How are they interpreting? How are they ascribing a will to the individuals in this study? So this is really basic science. The main cases, the three cases we're working on at the moment from Canada, although there was one pilot project in Ghana that IRIS organized. And so we're really just starting at the basics. Our hypothesis really is that this business of will recognition is something people already know how to do. People who are experienced supporters know how to do it. And so what we need to do is to figure out how to spell out what it is that they already know. We're at the tagging stage in that work. We're going through these videos very, very closely. And one of the interesting questions we're finding is, when is it appropriate to say of the supporter that they've recognized a will in a matter? That's a legally significant question. My part of this is really to bring some kind of philosophical perspective. The concept of the will has, for a very long time, been a central issue in philosophy and its history. In the Western philosophical tradition, this what we call the free will problem, the question about whether the will is free or not, has been one of the kind of central puzzles that philosophers have worked on. But I'm more interested here in the background question, which is, what is it to have a will? What is it that we're recognizing when we recognize someone as having a will? Again, I've only got one slide for this section. What we find in looking at the history of Western philosophy is that there are three different approaches to thinking about the will. The will is, a concept philosophers have been debating about for thousands of years, but philosophers think about it in different ways. So the first model is to think about will as a special kind of desire or an appetite, a special kind of want. And I've given three examples here from this tradition of Thomas Aquinas, the medieval theologian and philosopher, Thomas Hobbes, from the English philosopher from the early modern period, and Harry Frankfurt, who's a very influential 20th century American philosopher, who've all written about the will. All of them think about the will as a kind of desire. Aquinas thinks about it as the rational desire. Hobbes thinks about it as the desire that actually leads to action. And Frankfurt has a subtle theory about it. Anyway, that's the first approach. We think about when we're looking for the will, we're looking for a want. We're looking for a desire. That's what we're trying to figure out. What does this person want? A second tradition, it's actually older, thinks about will not as wanting, but as choosing among competing desires, right? On that first model, will was a desire. But on this second model, I've got a bunch of different desires. I want to go this way and I want to go that way. I want to go exercise, but I want to go to sleep. I want to be faithful to God, but I'm also really tempted by this sinful activity. That's Augustine's central case. So I've got competing desires in my deliberative space, and the will is this power of choosing among them. Augustine calls it liberum arbitrium. Liberum means free, and arbitrium means election or choosing, selection among options. It's the root of the English word arbitrary. So can we see there, this is a different way of thinking about the will. If it were just one more desire, it wouldn't solve the problem. It's a function or it's an operation that chooses among competing or conflicting desires. And then the third model is actually even the oldest. I'm going backwards in time here. This is Chrysippus, who's one of the founding figures of ancient Stoicism. And Chrysippus thinks about willing as assenting. Assenting is like saying yes. The dissenting is saying no. So Chrysippus thinks about the will as a function of either saying, yes, I will, or no, I won't. I'm faced with some offer or proposal or plan, and I respond with my will by saying, yes, I will, or no, I won't. So can we see those are three options that the philosophers have explored in thinking about what the will is? And can we see for the task of will recognition, it depends a lot which one of those one ends up focusing on. Part 5, wanting, willing, preferring. Here we go, more philosophy. Here's a principle for me. Not all wanting is willing. I might want something, but I actually don't will to do it. My example here, you can see this crowded bookshop. When I go into a bookshop, I find a lot of books that I want, usually too many. There are a lot of books that I desire to have, but that's not the same as willing to buy it, right? It's one thing to want the books, it's another thing to will to buy them. So oftentimes I find that I want lots of things, but I don't actually will to buy them. We also know that there are lots of things that we want, but we don't actually go on to act upon them. So I think that whatever willing is, it's got to be more than simply wanting things. I might want to sue you, but that doesn't mean I will to bring a lawsuit. So principle here for me, fixed point, I think, willing has got to be something more than just wanting. So when we're trying to figure out what a person wills, it's not enough just to figure out what they want. Here I distinguish between 3 layers. Here I start with the middle one. So the wanting, desiring is one thing. I'm using those terms interchangeably. Preference is another, and will, I think, is yet a third thing. Start with the middle term. I think preferring, remember, will and preference is a key idea in Article 12. I think preference is an intrinsically comparative notion. I prefer this book to that book. It's a ranking notion. It originally comes from economics, right? A preference ranking. So when we're talking about somebody's preferences, we're talking about ordering, or ranking, a kind of hierarchy. Wanting and desiring is not like that. It's not intrinsically comparative. I see a particular book and I want that one, right? Or I'm really thirsty and I want that drink in front of me. It's not a ranking notion. It can just have a particular thing as its object. And then I want to say willing is something distinct from both of those. Willing is something special, and here I'm going to go with the Stoics. I want to call willing an up or down response to an offer. It's like thumbs up or thumbs down. You're making an offer to me. Do you want to take this residential placement? Do you want this supporter? Do you want this medical treatment? And do you want to go swimming today? I'm either giving you a thumbs up, that's I will, or a thumbs down, that's I will not. That's the Stoic model. In English, we have this expression willy-nilly. It comes from will I or nil I. So it's either yes, I will, in Latin volo, or no, I will not, which is nolo. So what I want to argue here is that the legally significant notion of will is best understood as this volo nolo, I will or I will not, thumbs up or thumbs down. That's what we're really looking for. And when somebody expresses their will, they are saying, hey, recognize me, right? I'm telling you, I don't want this. Thumbs down. I want you now to recognize that and act upon that. So there's a kind of fundamental recognitional relationship involved in willing. It's intrinsically intersubjective. It's an answer to a question or a proposal. Okay, I hope that's beginning to bring into view the way that we have come to be thinking about the will. I have to say, methodologically, this has involved a collaboration between IRIS and the Autonomy Project. We've, from the Autonomy Project, really been bringing this kind of philosophical, historical exploration of this concept of will, but we're really using it on this video project in order to try to figure out what's going on in terms of these expert interpreters and supporters. What are they doing? And so what's emerging from that is this idea that the really significant notion of the will is that thumbs up or thumbs down. Willy-nilly, volo nolo, I will, no, I will not. Just want to say a few words here. This is very short. Part 6, radical interpretation of speech act schema. And this really derives from work that Michael and I have been doing with Jo Watson in Australia. She's a speech and language therapist. And I think of speech and language therapists as being really key human rights allies in the struggle for recognition of the rights of persons with disabilities, especially in this group I'm talking about, where you have severe cognitive and or communicative disabilities. So I'll just introduce this notion. I don't want to spend too much time on it here, but it may be of interest. So radical interpretation is a concept from philosophy. It was developed in the 50s and 60s. And the original way in which it was used in philosophy of language was in this way, was defined as the task of ascribing beliefs and desires to a person with whom the interpreter shares no common language, and for which no dictionaries or interpreters are available. In the original kind of philosophical discussions about this, there was a kind of colonialist overtones to it. You were invited to imagine that you were parachuted in to some remote location with a language that had never been studied by anyone from your civilization before, and your task was to write the first dictionary. How would you go about it? How do you get started in that radical task of interpretation? I want to modify that notion a little bit for the work we're doing. I want to talk about radical interpretation as the task of ascribing a will in a matter to a person who may have no recognizable language at all. Maybe their cognitive or communicative disability is so severe they never acquired language, or maybe they have an idiolect. But our task is task of radical interpretation. How do we go about figuring out what their will is, where we can't rely on a kind of background shared language? I'm not going to answer that question here, but I find that to be a useful framework for thinking about the nature of this task. And with Joe's help, we've been thinking about a 4-phase model. I'm in that situation. Phase 1, I recognize that the person is trying to communicate. They might be making certain vocalizations, or they might be moving around in space or gesticulating in different ways. And I recognize, hey, they're trying to communicate something, right? That's the first phase. This noise they're making is not snoring or sneezing or involuntary noises. No, there's communicative intent. I might not know what it is, but I can see that they're trying to communicate. Secondly, and here comes in a concept from speech act theory, I recognize that the person is engaged in a particular illocutionary act. That is, they're asking for something, or they're protesting, or they're expressing approval, or they're providing information. I might not know what it is they're trying to communicate yet, but I can see that that's what they're trying to do. They're upset about something. They're communicating their objection about something. Phase 3, I figure out what the object is concerning which the person is communicating. So where my cat comes in, they're communicating about the cat, or about the fact that the cat is on the mat, right? I figured out what it is that they're trying to communicate about. We call that the object of their communicative act. And then the 4th phase, culminating phase, is that we identify the content of the communication. They don't want the cat to be on the mat, right? They're upset about that, or they're delighted about that. They're trying to communicate some content about that object. Now, I emphasize those 4 stages don't come sequentially. They don't always come separately. They might just all, in a typical case, they'll come all at once. It's just immediately clear that this person is communicating that they're unhappy about the cat being on the mat again. But in other cases, they can come separately. And we might be sure that the person is communicating about the cat, but not know what they're communicating about it. Or we might have phase 4. We know that they're objecting to something, but we haven't figured out what they are objecting to. So we found it useful analytically to separate out those 4 stages when faced with these tasks of radical interpretation. Okay, I'm coming to the end, and I'm nearly out of time. Part 6, in a way, this is a bit of summation. But there's one little section after this that I'd like to add. So I call part 6 towards a more inclusive regime of legal capacity. So remember where we started. We've inherited thousands of years of regimes of legal capacity that have been exclusive. They've gotten increasingly inclusive, but many, many people with disabilities are still left on the outside. I've been particularly concerned here with persons who might have severe cognitive or communicative disabilities, which make it difficult for them to be recognized as having a will. But that also might be people who have psychiatric disorders, and they fall in the shadow of the Justinian axiom. People say, oh, those people don't have a will. We hear that sentence a lot. Those people don't have a will, a way of pushing them out of the regime of legal capacity. So here's some of the points that I've been trying to make. I think we stand at a fateful moment in the history of disability rights. We're now far enough that the 2006 convention and then General Comment 1 for all of its problems and flaws, these were hugely important documents in advancing the movement and advancing research and discussions and law reform. So we're in a very rich moment, and it's really beginning to pay off. There's a global movement, as is evidenced by this very meeting, and a legal imperative to devise more inclusive regimes of legal capacity. And then what I've been trying to argue here today is that recognition of a person's legal capacity requires recognition of the person as having a will in a matter. That's a specialized concept. It's not the same as just wanting something or having a preference. It's a very specialized and legally fundamental notion. I hope I've convinced you of that. Fourth, expanding access to human rights and legal capacity for persons with cognitive and communication disabilities require that we develop a better understanding of what I'm calling the practices of will recognition, will discernment, will ascription, will attestation. One key aim, fifth, should be to develop standards for legally authoritative practices of will recognition. As a society, as different societies, we need to come to an agreement about what counts as sound, valid evidence that this person wills to do this or that. What counts? We need to articulate that for ourselves. I think that's going to be an ongoing process, but it's, I think, a vital piece of the overall law reform movement. And finally, development of such standards requires research, starting with research into the ways that experienced supporters recognize the will of the persons they support. We're not trying to reinvent the wheel here. Will recognition happens all the time. Will recognition happens in the face of severe disabilities all the time, every day. But we need to figure out who are the experts, who are the people who are doing this, and what are the best practices and standards, and how do we then teach it to other people and gain legal recognition for those practices. So we're looking for allies, because I think this is a very large problem, and I think it plays out in different ways, in different legal jurisdictions, and in different background cultures. You will have noticed that the history that I've been recounting here today has been very Eurocentric. It's about Greek philosophy and Christianity and Roman law. So the concept of will has in part come to us down that path. But we need to look more broadly at different legal jurisdictions, at different legal traditions, at different cultural backgrounds in order to gain a fuller understanding of these matters. Finally, I got 2 minutes left. I just want to mark something as an addendum for discussion. This is somewhat unrelated, although I think in the end it does tie back in. So I just want to raise this, and if we have time, we can discuss it in the question and answer session. And it's about what I'm calling the division of labor between the family and the state. So let me just explain what I mean. I'm going to bring in another European philosopher, dead white male, in this case, Hegel. Hegel says that all modern societies have three fundamental structures. He calls them the family, civil society, and the state. So the family, we know what that is. Well, although it's constantly changing. The state, we know what that is. It's constantly changing. Civil society is, well, organizations like this, Inclusive Asia, but as well as businesses and Zoom and all of that. These are things that are part of civil society. So 3 layers. Society is a kind of 3-layer cake, according to Hegel. So that's common to all societies, according to Hegel. I think he's right. But the division of labor among these 3 elements in society varies dramatically over time and across cultures. What do we expect the family to do? What do we expect the state to do? What's the role for civil society, right? That's not the idea that there are those three layers to the cake, that's more or less a constant in modernity, but the way in which they interact, the division of labor among them, that's something that changes. And here I'll just give you an example, in this case from care for the elderly. So here in England, in the United Kingdom, the state has a large role in organizing living arrangements for elderly persons living with dementia. If you have dementia in the UK, it's very likely that the state will be involved in deciding where you receive care and what kind of care you receive, and in regulating that care. Depending on how wealthy you are, they might be paying for that care. So the state is really involved in your life. That includes depriving you of your liberty. You might not want to go to the care home, but the state might decide that's the place, the safest, best place for you. Now, these living arrangements are themselves delivered in the UK mainly by civil society organizations, private corporations, charities, religious organizations, and so on, that run care facilities. So that's a kind of a specific configuration here in England, which, by the way, is the first industrialized country, right? The Industrial Revolution happened here, and this disrupted family structures. But in other cultures, such arrangements are made within the family. The state might not be involved at all, or in commercial transactions in civil society or between the family and civil society. I think that makes a huge difference. I was last summer working with an NGO in Japan, and I really began to see the way the division of labor between the family and the state in Japan was fundamentally different than the one that I'm used to here in the UK. When I've spent time in China, China obviously has a very distinctive state. And one of its functions historically actually has been to break up family relationships, which historically, we go back 100 years, the party saw as a threat. So there's a different relationship here among these three elements of civil society. So I just want to hear, as my last point, raise for discussion this thought. Although human rights standards are universal in scope, the CRPD applies to the whole world, their practical realization and the tactics required to achieve compliance must of necessity vary, depending on the local division of labor among family, civil society, and the state in matters that impact upon the rights of persons with disabilities. So I hope maybe we can discuss some of that. I've added a slide here with some further readings. I'll provide the slides to Chine, and she can disseminate them so you can have access to, I've put down some of our outputs here, but there are many footnotes within those that will take you to other key sources. Thank you.
Thank you very much, Professor Martin. And now we will have a 5 minutes break. And after the break, we will have the Q&A session. And perhaps we can go back for the last discussion point, the last point you have mentioned before. So please don't go away and come back in 5 minutes. Let's come back in 9:10. Okay, have a break. Now we will have the Q&A session. So we have about 20 to 25 minutes for today's Q&A session. Yeah, I have already seen some questions in the chat box, and we will go with the question in the chat box first. And if you have any other questions, you can also type in the chat box, or you can You can wait, and when we finish the question in the chat box, you can open your microphone to ask the questions. All right, I have seen the first question from Stephen, and the question is, Chinese law, like many other legal jurisdictions, often emphasizes the relationship between individual rights and interests and collective rights and interests. So the question is, how do we reconcile the will of the individual person with the perceived will or interest of the family, community, or wider society?
Good. Thank you, Stephen, for that question. In 2012, I taught in China for a month, and we had 2 meals a day with the participants in that summer school. And I was advised before going to China that it was not a good idea to talk about politics, because I would not be the one who would be exposed to risk. But at those lunches and dinner, everybody wanted to talk about politics. And this was one of the crucial questions that came up again and again. I don't think there is any straightforward answer to it. But I guess to me, I would at least draw a distinction. I mean, first of all, it's fundamental to human rights that there is not just one of them. Human rights are, by their essence, multiple. They're plural. And because of that, there are conflicts among them. Inevitably. Not every time, but inevitably those kinds of conflicts come up. And so we need reasonable and rational and fair mechanisms for resolving those conflicts. And over the centuries, lawyers and philosophers and activists and lawmakers have come up with those mechanisms. Some of those mechanisms are democratic mechanisms. Representative democracies weigh up competing interests and then vote together in order to figure out how best to do justice to different rights. Sometimes we use legal proceedings, principles of proportionality and weighing, and so on. But among those conflicts, I would distinguish between 2 different kinds. One is, as regards individuals, there's a conflict of rights. So that might be, for example, that my right to choose who to live with is in conflict with my right to security. If I choose to live with somebody who's really a risk to me, there's a conflict of my rights at play in that circumstances. In other cases, it might be my rights against your rights, and we need to weigh up, we need ways of reconciling those. Sometimes it might be broad. This is something we talked a lot about in China in 2012, rights of the head and rights of the belly. The right to be fed, right? The right to have health care, the right to have a meal, the right to have clean air, as opposed to the rights to freedom of thought, of expression, the right to vote, and so on. So these are a range of different individual rights coming into conflict with one another, and we need mechanisms for resolving those conflicts. But I think what Stephen is asking about here is something different, which is about a conflict between the rights of individuals and, how did you put it, Stephen? Collective rights, the rights of the collectivity. I think that's a different thing, because on this other one, we're always talking about individuals as the bearers of rights. Those rights come into conflict. We need mechanisms for resolving them, but it's always the rights of somebody as an individual. The thought here is a much more radical one, which is somehow that there might be rights of the collectivity as a whole. I think that's something we need to think hard about, but I think it introduces a whole different layer of complexity. I myself, broadly Hegelian in thinking about these things, I think collectivities do have rights. I think, for example, the state of Ukraine has a right to self-determination. And it has that claim against other states. So that state to state, we have rights that need to be balanced and adjudicated. But the idea that the rights of the whole then conflict with the rights of individuals, I think that raises very, very challenging questions. I don't have a general answer to it here, but I think that it's something that does sometimes happen. Right now, for example, in Ukraine, as regards the right to decide whether to serve in the army or not, the right to leave the country if you're a young man. So these are conflicts that come about. I don't see a general solution to them, but I think in general we need to view them with some skepticism, because ultimately communities are made up of individuals. And so I think if we can honor the rights of the individuals, the rights of the community will take care of themselves.
Thank you very much for the response. And the second question in the chat box is about the role of substitute decision making. So the question is, I embrace the vision that supported decision making should replace the substitute decision making. However, we may encounter extreme scenario in which someone at times needs others to decide for them on crucial matters due to confusing mental state, especially for Hong Kong, in which family members lack the capacity to support them. Should we say that substitute decision-making, such as involuntary admission to mental hospital, have to be altogether demolished, or we should advocate that we should treat substitute decision-making arrangement as the last resort, and for the extreme scenario, we should ensure adequate safeguards to it and add in supported decision-making components?
Thank you. So I've just put my slides up here briefly because these are questions that we have researched extensively. And I just refer you in particular to the last item on this list, that what's called the 3 jurisdictions report. Again, we'll disseminate these links, or you can find that on our website. All these materials are on our website if you just Google Essex Autonomy Project. So there are different views about this, about whether substitute decision-making should be abolished. Our argument in that report, which was written for the Ministry of Justice here in the UK, was that the convention does not require the abolition of substitute decision-making. That is to take a view that diverges from the committee's views in General Comment 1. I mean, one thing I'd encourage you, if you look at that report, you might start by reading Appendix B. Appendix B is a synopsis of the travaux préparatoires that led to Article 12. And one of the things that you will see there is that the committee that drafted the convention were of different views about whether substitute decision-making should be abolished. And in the end, they adopted language in full knowledge of the fact that it did not require the abolition of substitute decision-making. Now, some nations around the world are moving in the direction of the abolition of substitute decision-making. And I think we should watch carefully to see what happens there. It's, of course, one thing to abolish it in law. It's another thing to abolish it in practice. But I think we're at a moment where different nations around the world are taking different paths. And I think that the convention is a broad document. I think it's clear that it requires more inclusive regimes of legal capacity. It's very clear that it requires new mechanisms for support for people to exercise their legal capacity. But within those boundaries, I think there's room for, well, what people sometimes call a margin of appreciation. So I think we should watch carefully. I myself do not advocate for the abolition of all mental health laws or involuntary treatment. If we had more time, I would tell you some particular stories, both about my own life, but also about things that I've witnessed. I think, for me at least, there are circumstances, particularly extreme circumstances, where I would want people to override my will in order to keep me and in particular other people safe. So I think there's scope for that. But I think that that scope should be narrow, and that there is a huge amount that we should be doing in order to expand to have more inclusive regimes of legal capacity. Right now, we're far too reliant on substitute decision-making, and the mechanisms of supported decision-making are still in their infancy. But anyway, I recognize that's a controversial position within the movement, but it's one that we defend in that report, and I'd be happy to discuss with people who are interested in taking it further. Thank you.
Thank you for the response. And I think it's very interesting that I think it's difficult to hear some scholars to say the personal opinion that perhaps we do not have to abolish substitute decision-making at all, especially in Article 12 context. And that's really a very interesting opinion, and we're looking forward for further discussion on that. And for the next question is, people with severe intellectual disabilities may not be able to understand what, for example, residential placement entail, because there are so many possibilities and options. So in this kind of circumstances, what are the measures that can be put in place to ensure that the will of the individual is discerned and respected?
Great. So thank you for this really important question. So I use a metaphor here that comes from computer science. In computer science, we talk about distributed processing. There are different kinds of distributed processing. Distributed processing is when you use more than one computer to solve a problem. And sometimes you use massively distributed processing, where you use many computers to solve a problem. So I think I find that to be a useful metaphor, and there's actually a very advanced theory and practice of distributed computing. How do you do it? How do you make sure that these systems are working together in order to solve a problem? I believe that in human affairs, we also engage in distributed processing. One place I see it very concretely is in families where there's a person with advanced dementia. As the dementia advances, the person begins to forget ordinary words. And so they can't complete their sentences. They get stuck. They get frustrated. When they get frustrated, they get more stuck. But there's often another person in their world, a partner, a child, a supporter. And when they get to the word they've forgotten, the supporter can help them remember what it is. They propose the word, and the person either agrees or disagrees. Either, yes, that's it, or no, that's not it. That's an example of distributed processing in human affairs. Communication is happening. It is the person who's communicating, but they're doing it in this distributed way. I think we do the same thing with decision-making all the time. We face a complex decision, and so we we engage in what we call cognitive offloading. Cognitive offloading. This is a concept that comes from cognitive science. There's a load that is too heavy for me to carry all by myself, too complicated, and so I outsource it to somebody else. We do that in business, right? As my business grows, the payroll becomes too complicated for me to do it all by myself. So I bring in an accountancy service. I'm outsourcing, I'm offloading, I'm cognitive offloading. It's still my business. It's still my communication. It's still my decision making, but I'm offloading some of the load to others so we can carry it together. Now, remember, I've advocated here today for a very particular way of understanding the will. The will is an up or down response to a proposal, a plan, a question. Do you want to do this? Yes or no? Volo or nolo? Now, a volo or a nolo, a yes or a no, is only meaningful if I understand the question, right? Well, hang on. It's only meaningful if the question is understood. So let's take the case that's been discussed here in the Q&A. There is a proposal for me, a person with disability, to take a particular residential placement. And that particular residential placement is going to cut me off from the principal person I enjoy spending time with. It's going to make it very hard for me to see them regularly. So the question is posed, does Wayne want to go, does he will to go to this residential facility? I myself might not be able to understand that proposal. It's too heavy a cognitive load for me to understand. But you know me. You know what I value. You've been interpreting me for year upon year. You know in particular how much I value spending time with that one person. And so together, in a distributed way, we can say, you know what? Wayne says no to this proposal. Wayne by himself can't understand it, but together we know enough about Wayne to know what his will is in this matter. So that's an example of offloading, of distributed capacity in the recognition of will. And what we need to be able to do in order to achieve inclusive domains, regimes of legal capacity is to achieve legal recognition for that kind of offloading. So I see the potential here. Again, remember the way I put it. It's not that Wayne needs to understand the proposal. It's that the proposal needs to be understood. But that might be done in a distributed way, such that it makes Wayne's up or down, volo or nolo, a legally significant one. I hope that helps to address the question. I see this as a huge domain for further research, further practice development. But again, I think it happens all the time. So we need to develop our understanding of what's happening. Thank you for that important question.
And really thank you for the vivid example. It's really helpful. I see someone raise hand in the on the screen, but can we just respond to another question in the chat box, and we will invite the person raise hand because the next question in the chat box is quite relevant. So the question in the chat box is that whether your theory can apply to mental capacity. As we know from the general comment number 1, that mental capacity is a separate idea, separate concept from the legal capacity. So do you think your theory can also apply to mental capacity? Or is mental capacity just a biomedical concept according to your theory?
Good, thank you. So this is an area where I find myself in disagreement with general comment 1. I think that by mental capacity, I mean, first of all, it's very important not to confuse mental capacity and legal capacity. Mental capacity really means decision-making capacity, the ability to make a particular decision in a particular matter at the time when it needs to be made. That's what we're talking about. So it's in GC1, they describe it as a set of psychological abilities. I don't think that's right. I think it's a set of psychosocial abilities. I think that it's partly about what I can do with my mind. Those are the psychological abilities, but it's also about the ways that I can work with others to do things that I can't do alone. So that's the social part of it. And that's recognized in the Mental Capacity Act here in England and Wales, especially in section 1.3. So that's what mental capacity is. Mental capacity is something that we assess. We try to figure out whether someone has it or doesn't have it, how we can support them to have it or not have it. Legal capacity is different. Legal capacity is not something we assess. Legal capacity is something we recognize. Legal capacity is something we really are meant to guarantee, that all should have legal capacity on an equal basis in all matters. So the concept is different, the modality is different. I don't think that either of them are biomedical concepts. Legal capacity is certainly not. Legal capacity is one of the most ancient legal concepts. It's to have a status in a society and in law in order to be able to make changes with legal effect. It goes back as far as law goes back. Mental capacity, you will never measure it with a neuroscanner. There have been attempts to do that. They have all been failures because it's a psychosocial concept. It's socially embedded. It's not really a psychiatric concept, although psychiatrists get asked to testify about it. It's a question about when are you able to make decisions. So I think that it's really important to remember that what Article 12 calls for is support for the exercise of legal capacity. We talk about supported decision-making, but that's actually not in the convention. What's in the convention is support for the exercise of legal capacity, for support for being a legal agent. Now, one way that that can be done is to provide support for decision-making capacity. That's what MCA 1.3 is about. No one shall be found to be lacking in decision-making capacity unless all practicable steps have been taken in order to help them make a decision for themselves. So you might be able to help me to exercise my legal capacity by taking steps to support my mental capacity. That's a strategy. But we need other strategies as well, because there are people out there, that will never pass that capacity test. And we need to figure out how to support their legal capacity as well. That's very much been Michael Bach's message for decades, and it's a view I very much share with him. Does that mean we can get to everybody, that every single last person can have full legal capacity in all matters? Well, I don't know. I'm skeptical, but let's go as far as we can, right? Let's work together to develop strategies. So in answer to your question, my theory of distribution, of offloading, the answer is yes. It does apply both to mental capacity and to legal capacity. I think distributed capacity is a concept that applies in both of these domains. Together, we can do something that I couldn't do alone. Together, I can make a decision with your help that I wouldn't have been able to do by myself. So I have mental capacity. Together, I can exercise my legal capacity in a way that I wouldn't be able to do by myself. So yes, I think that this distribution or cognitive offloading model is one that applies in both domains. We discussed this further in that same report.
Thank you for the response. And now I can see Aravinda. I'm not sure whether I made the right pronunciation. So yeah, I see the raised hand, and please introduce yourself and also ask your question, please, as briefly as possible.
Thank you. I hope I'm audible.
Yes.
Yeah, so I'm Arvinda, Dr. Arvinda Bhatt from South India. I'm a literary studies scholar, and very recently I've picked up an interest in legal personhood for the disabled. I myself am a blind person. I identify as blind. So my question to you, Professor Martin, is it pertains to legal personhood here. You have addressed the concept through the idea of the agent, the legal agent. Now, don't you think that when you say, that we can talk about the expression of the will of the person with, a disability, a severe intellectual disability or a psychosocial disability or whatever, aren't we assuming already that his or her or their will is already recognized by the legal system, whereas more often than not, the person with a disability is not recognized as a legal agent in the first place?
Yes, thank you. So the concept of legal personhood, I would want to draw a distinction. I think there's an ambiguity there, because to be a legal person might mean to be a person before the law, and in that sense to be a bearer of rights. So what I was referring to as passive legal capacity. So an infant, for example, a very young child, is a legal person. So, by the way, is a corporation, right? Because a corporation is viewed as having rights and able to make changes with legal effect. So I think that but if we're talking about full legal personhood, then we need to be talking about legal agency as well. And there, I think that part of the argument I've been trying to make is that at least for the last couple of thousand years, that notion of legal personhood has been inextricably tied to the notion of will, of having a will, and to the practices of will recognition. It starts really in Roman law. It does not go all the way back. In the Spanish paper on in the slides, I talk about the earliest history of this in the European context in the 6th century BC, when inheritance law was changed so that people could choose their heirs. So, but it emerges, and by the time we get to early Roman law, the notion of being a legal person and the notion of having a will go together. So if I'm excluded from one, I'm excluded from the other. Does that answer your question?
Yes, no, I would say partially, but I don't want to take up too much time. But my question was, when we talk about the expression of the will, isn't the will already assumed to be recognized? I mean, how do we get around this problem that a disabled person may not even have the platform to express their will in the first place?
Yeah. So I guess, I think there certainly are circumstances where we don't recognize a person's will. We can't figure it out. We can't figure that 4-phase radical interpretation model I was talking about. We get stuck, maybe at the very first level. And so there are circumstances where we just can't recognize what someone's will is. So I don't think it's something that's presumed. I think it's an achievement. It's a complex hermeneutic achievement in order to recognize a person as having a will. And there may be cases, extreme cases, where people don't have a will. We ask sometimes people to make choices among options that they just can't understand, or even with help. And so it's not meaningful, I think, to seek out their will in that matter. So no, I don't think it's presupposed. I think it's a challenge to recognize the will, and it's an open question in any particular case whether we can do it or not. But I think we have a legal obligation. You saw that in the Peruvian language. We have to make real, serious attempts to figure out what the will is. So I think it's a kind of work. It's a kind of hermeneutic work to find the will. But the presumption should be we're all capable of having it. It's at least a possibility. Nobody should be written off. Someone in the chat talked about the deaf being treated as having, it was Fifi, I think, said that Fifi knows of cases where it's just been said, because a person lacks hearing, they don't have a will, right? That can't be right. It has to be a task of work in order to try to figure it out, and we should be committed to that. We should move on. Thank you for your question.
Thank you. Okay.
Because of the time limitation, we may have only the time for one question in the chat box. So the chat box, the question in the chat box is about elder people. The question is that Professor Martin at the first slide in the beginning has included the elder people into the legal capacity regime, especially the new legal capacity regime. But the following content is more about persons with disabilities. So the question is why Professor Martin include elder people into the new legal capacity regime?
Thank you. Yes. So that was another outcome of the last year's World Congress on Adult Guardianship in Edinburgh. Again, the challenge of achieving compliance with the CRPD is extremely broad because disabilities are incredibly diverse and there's all kinds of intersectionality and so on. So this is not a one-size-fits-all kind of problem. I've been focusing today on the kind of theoretical legal structure of legal capacity and then the particular way in which that impacts on certain kinds of disabilities. So I'm not trying to give a kind of a general theory. So I've been focusing on certain kinds of psychosocial disabilities, dementia, which is obviously very much more prevalent among the elderly, and then other kinds of cognitive and communicative disabilities. That's the particular group I've been interested in here, in part because it brings out in a very vivid way some of the challenges around will recognition. But I do think this was I can't remember the name of the speaker at the World Congress last year who made a really moving speech about this. And if you contact me, I can dig it out, the reference, which is that it's important to think about this additional category. It's a conjunctive category. It's an and category where there's also a lot of intersectionality. And we don't want to think about being an elderly person as being a disability. Although elderly people do have high incidence of disabilities. And especially we were working last summer in Japan. Japan is a super aging society. And there are a lot of common challenges that apply to the disabled population in Japan and to the elderly population in Japan. Both of them suffer forms of social exclusion and denial of full recognition of their rights. And so I think it's helpful to think about the challenge that I'm talking about. It applies both to regimes of legal capacity that are as inclusive as possible of persons with disabilities, but also to ensure as much inclusion as possible for the elderly. And I think many of the same strategies or variants on the same strategies can help with both populations. So I see an alliance there. I see a fruitful form of intersectionality that's both a high risk, but also an area for a lot of potential gains in thinking about reform of law and practice. So that's the reason I'm putting them together. And in fact, there are many people who belong to both groups.
Thank you, Professor Martin. And because of the time limitation, although I can see there are other people raise hands, we may not have time for the Q&A session. And if you have any other questions, you can email the question to Inclusive Asia, and we will collect the question and then email to Professor Martin to have a further response. And now the email of Inclusive Asia is available in the chat box. And also thanks again to Professor Martin, and there are a lot of super good comments on today's lecture. Some of them are in Chinese, so just let you know there are some super good comments in Chinese on you. And also as the last thing, I will give you the preview of the next lecture. So in next week, we will have Miss Carrie Joffe from Canada, the Arch Disability Law Center. She will share with us the barriers to access to justice for persons with disabilities and civil society-led initiatives to enhance access to justice. She will also talk about legal advocacy addressing discrimination against women with disabilities with an intersectional feminist lens. So it's also a very interesting topic, and also we will send out the information of the next lecture through the email and also WeChat group. So this is the end of today's lecture, and we will see you next week. Thanks again for everyone, and good night.